The number of common law couples across the country is growing 4 times faster than the number of marriages. But if you're currently in a common law relationship, do you know your rights if you separate? Well, joining us this morning is family lawyer Stuart Zukerman to talk about those rights. Good morning, Stuart. Thanks for being with us.
Good morning. Thanks for having me.
So a lot of couples may be feeling increased pressure of the self-isolation that we're all under and maybe considering going through a separation. So to start things off, maybe clarify for us, what is a common law spouse?
So a common law spouse really just means an unmarried spouse. So a couple that has never married but are living together in a spousal-like relationship. And in order to qualify as a common law spouse, you have to be living in a spousal-like relationship with your partner for 2 or more years. So once you've lived with someone for 2 or more years, if you subsequently separate as a common law spouse, you have all the same rights as a married spouse has in British Columbia. So you have a right to an equal division of the growth and equity of the assets or the debts. And you have a right to spousal support, just as if you were married.
Okay, so same rights then. So does that mean both married and unmarried couples are entitled to a 50-50 split?
So it's not exactly that way. The way it works with both married and unmarried couples is that the Family Law Act excludes from division the equity that either spouse brought into the relationship on the day they began cohabiting or on the date of their marriage. But the growth in equity of any of the assets that they've brought in are subject to a 50-50 split. So if you got together and on the date you got together, your RRSP was worth $100,000, and then when you separate 5 years later, your RRSP is now worth $150,000. You would get to keep your first $100,000 that you had, but the growth of the remaining $50,000 that grew would be split 50-50 between the spouses, and that would be exactly the same way the court would treat the division of equity in a home. So as the equity increases over time due to market forces or mortgage payoffs, that equity is split 50-50, and the same thing happens with debts. They are the debt that either party brought into the relationship is their own debt, but the growth in debt over the course of the relationship until separation is subject to a 50-50 split.
So are there any exceptions to these rules, Stuart?
There are, apart from the court preserving whatever equity each spouse brought into the relationship as being excluded from the division between the spouses. The law also says that if it would be significantly unfair to equally divide any given asset or any given debt that accrued or increased during the course of the relationship, then the court can order an unequal division. And the onus of proof is on the spouse who's arguing that 50-50 would be unfair. That person has the obligation to prove to the court's satisfaction on the evidence that it would be significantly unfair to divide the assets equally.
Yeah, it's such a difficult decision for couples, common law or married, to make the decision to separate. So if we're talking about a common law couple here, is there something or are there things that they shouldn't be doing when separating?
There are a lot of do's and don'ts when you're separating, and this would apply whether you're common law or married. The first thing I can say, having practiced family law for over 30 years, is don't cut off financial support. So if you're the breadwinner and you're the bill payer in the home, and then you have a big fight and you separate, what typically happens in common law is emotions rule, and the person who pays the bills a week later says, you know, I'm done, cuts off the hydro, cuts off the telephone, cuts off the cable. And I can tell you as a lawyer, if I go into court in front of a judge and I portray the other party as the bully who cut off hydro and cable and internet for the wife and kids the day after they moved out of the home, the judge is going to say to me, you know, what can I do to help? Tell me what your client needs. And that person is going to be nailed to the wall for taking that approach. So don't cut off finances. Don't refuse or fail to exercise ongoing regular parenting. So some parents, they split up and mom says, okay, I'm not going to let dad see the kids anymore because he cheated on me. That's a bad approach. Courts don't look at that well. In fact, courts favor awarding primary care to the parent who supports shared parenting. So if one parent is stingy that way, that's not good. Don't act from your emotions. You have to step back and take some time and get advice, ideally from someone other than friends and family. Friends and family will tell you they know what the law is, but they're not lawyers, and you shouldn't rely on friends and family for legal advice about what happened in their divorce or their sister's divorce. Go to see a lawyer. get independent legal advice and understand your rights and your obligations. And lastly, whatever you do, don't sign anything, don't sign an agreement or enter into an agreement verbally or written with someone until you've had the terms of those agreement reviewed by a family lawyer who can tell you whether you're agreeing to something that's reasonable or unreasonable.
Well,
So those are the main don'ts.
Hopefully, no matter what path a couple takes, they can do it amicably. Stuart Zukerman, thanks for joining us this morning.
Great to be here. Thank you.